Pamela Rue Holdings, LLC.
Good afternoon, Your Honor. Ellie Kirsten on behalf of defendant.
All right. And where are we on this case?
Your Honor, the last time that we were before you on this matter, the court had some concerns about jurisdiction. We have filed a bench memo detailing the jurisdictional basis for this matter. We are not sure if the court has had an opportunity to review that at this point.
Oh, I did, and I read it.
Then, Your Honor, our position is fairly clear that under MCL 600.5704, the court has a general grant of jurisdiction over summary proceedings to recover possession. And that is exactly what we are seeking here under two distinct subsections of section 5714.
Right, but under that notion, you're seeking this as a non-payment of rent as opposed to a termination, correct?
Your Honor, this is an action where we have multiple bases for seeking possession. The first theory was under a non-payment of rent theory, as there is still outstanding balances that, as defined by the lease, are rent and have not yet been paid. But separate and independent of that, through subsection CI, after termination of a lease, pursuant to a power to terminate provided in the lease or implied by law, the court is also empowered to grant possession. And in this case, there have been numerous independent events of default. We have opted to terminate the lease and provided notice of that, despite the lease itself stating that no notice was required. There has been notice. At this point, the defendant is still occupying the premises. The lease has been terminated, and we request that the court grant us possession in light of that.
Go ahead, your turn.
Your Honor, it's defendant's position that the court lacks jurisdiction to hear this summary proceedings matter. As to the first point about jurisdiction for non-payment of rent, the amount stated in the notice to quit was paid by the defendant, the $16,000 and change. I have the exact amount if the court needs it. So that amount.
There was presumably a late fee that kicked in. I'll let you finish your points, but one thing I was trying to figure out, that payment of the 16,000, I think 400 something, whatever it was that paid prior to the filing or institution of this action, or was that paid after it?
Your Honor, I could answer that question. There was an original letter sent that there was an outstanding sum of $32,000. Half of that was remitted. The other half was not. This action was initiated, and since then, $16,000 has been remitted. However, there is still an outstanding balance that is attached to a late payment from June. And I would direct the court to the lease itself, which states that.
You're not answering my question, because the answer to my question doesn't make that long. At the time of the filing of the complaint, had the $16,000 been paid?
No, Your Honor.
Okay.
Your Honor, if I could clarify, so as plaintiff stated, $32,000 was originally owing. $16,000 was paid on June 16th. The notice to quit was issued, indicating that the second half of the payment was made and that it was due in 7 days. And that second half was paid by the date listed on the notice to quit.
So, okay. So both of those cannot be true. Because you couldn't have filed a complaint for non-payment prior to the expiration of the notice.
Your Honor, from my understanding, the notice to quit was dated June 16th and the complaint was filed that same day.
Is that right? Counsel?
Your Honor, yes, Your Honor, both of those were filed on the same date. The issue with the non-payment of rent here is that that was an event of default under the lease. That notice was provided in an abundance of caution to dot our I's and cross our T's, but the non-payment at issue independently created a basis to terminate the lease, which was exercised.
Whoa. No. Did you read the notice that you gave them?
Yes, Your Honor.
And what's it say about the payment of the amount?
Your Honor, this notice, the non-payment of rent subsection is separate and distinct. If the court does not agree that this non-payment of rent provision, statutory provision, allows us possession, we would ask that the court then instead consider this under subsection C1.
Did you give them a 30-day?
Your Honor, the lease did not require a 30 days notice to terminate the lease.
You have to invoke the jurisdiction of this court.
Your Honor, we provided them numerous.
That's statutory. You can't just bring things to me on summary proceedings actions, whether commercial or you have to invoke the jurisdiction of the court.
Your Honor, we believe we properly have. We've provided them numerous notices and attempts to cure. They have not. And this assertion that they now believe the court lacks subject matter jurisdiction is inconsistent with their answer to the complaint.
I'm inclined, counsel, to agree with them. Because you took a non-payment of notice or a non-payment notice, effectively said you have 7 days to cure. They cure within that 7 days, but you file a complaint prior to the expiration of that notice. That does not invoke the jurisdiction of this court at all. So under that theory, yeah, I don't think you can proceed. Quite frankly, I can't proceed.
Your Honor, the non-payment was one of two events of default that we invoked in our complaint.
You keep saying that to me over and over again. Really, I'm not that old. I hear you. I heard you the first 2 times you've been telling me that. The problem is that then you try to invoke the court's jurisdiction without a notice at all. And I'm not sure how statutorily you can do that. And quite frankly, your memo doesn't help me.
If I may, Your Honor.
Yeah, go ahead.
We believe that we have properly terminated this lease. We believe that we've brought a summary proceeding for possession following a proper termination. Not only was there lack of payment, there are issues with other provisions of the lease, including inventory, supply obligations that were not met. 30 days notice was provided. They did not cure those deficiencies. We believe that there are multiple independent bases for these summary.
The 30-day notice was provided?
Your Honor, we sent them.
Did you file the complaint prior to the expiration of that 30 days? Like you did with the 7-day?
Your Honor, we provided the notice of material breaches on May 18th, and we filed the complaint on June 16th. And as of today, those remain uncured.
Your Honor, if I may, maybe provide some clarity. So she is correct that there was a letter issued on May 18th to defendant regarding what plaintiff believes were material breaches to the lease. As I believe was discussed at a hearing last week, we dispute that the material breaches. Nevertheless, there was a letter issued on June 16th that included the 7-day notice to quit and also indicated plaintiff's position that the lease was terminated as of April 23rd. It's my understanding that there was no formal 30-day notice. However, even if there was, it's defendant's position that this court lacks jurisdiction to hear these summary proceedings because plaintiff has continued to accept rent for June and July, which would further restrict the jurisdiction of this court.
Your Honor, the lease is clear that when an event of default has occurred, even if a later payment is made, it does not change the fact that an event of default has occurred, which entitles termination of the lease. If the court would like us to submit more fulsome briefing on the jurisdiction issue or amend our complaint to parse out those individual events of default that make the summary proceedings proper, we would respectfully request that the court grant us an opportunity to amend and do so.
Respectfully, Your Honor, if I just may respond to that point. The lease, she is correct that there is language in the lease. However, leases routinely, landlords routinely draft leases to include unenforceable provisions. The law is clear, as this court indicated earlier under Park Forest, that once landlord accepts rent for future months, that they waive their notice to terminate. And that is what has happened here. They have given the notice. They have indicated that the lease is terminated, but continued to accept rent as this case has proceeded.
And Your Honor, we have cited authority in our bench memorandum that we provided to the court a couple of days ago, stating that acceptance of rent does not foreclose the ability to proceed with a summary proceeding.
But can create a Park Forest issue.
And Your Honor, again, we would request then that we have the ability to amend our complaint and we can parse out each of these amounts of default, the proper termination of the lease, and the amounts that are currently outstanding, if that would help clarify the issues for the court and show why the court has proper jurisdiction.
It's actually very clear. The court is very clear. In terms of what I should do, it only becomes an issue of whether or not I give you an opportunity to provide more briefing to the court. But folks, also, as I understand, at this very moment, there's only $1,021 in dispute.
That's my understanding, yes.
Yes, Your Honor, there's $1,021.23 that comes from a June late payment.
All right. Here's what I'm going to do. I'm going to make a ruling and then guess I'm going to allow the other part. This court is going to specifically rule that as to the non-payment rent issue, for other reasons, but specifically for the reason that the complaint was filed prior to the expiration of the notice. Also, since the non-payment of rent is remediary, sure, the plaintiff or the defendant remediated by the payment, which this court believes would divest it of any jurisdiction, even if jurisdiction attached. I don't believe regarding the non-payment that jurisdiction ever attached because the complaint was filed prior to the expiration of the notice to quit, and therefore, and then also was paid prior to, well, not prior to the filing of the complaint, but would have been had the complaint been filed properly. It's the best way to put that. And so this court doesn't believe that it lacks subject matter jurisdiction over the case and that the subject matter jurisdiction hasn't properly been invoked in this court by the plaintiff. To the extent that even one were to believe that the court were wrong in that, this matter then upon it immediately being filed with the court, the defendant having been paid, the remedy should have been as to that issue dismissal. So whether it needs to be dismissed, whether it's with reference to the subject matter jurisdiction or just the factual basis of the case, would require its dismissal as to the non-payment of rent. As to the issue of the 30-day, this court, I will say, is leaning toward the issue that there was not proper notice as to that 30-day. And then to the extent that there was even that the notice was proper, the notice that was given, that we have a park forest issue as it regards this case. Now, sometimes agreeable that park forest may or may not be applicable to certain types of commercial circumstances as opposed to residential. Certainly the court will take a look at that. So what I'm going to do is then I'm going to adjourn to August 14th, 2026 at 3 p.m. I will allow each side to file a brief to the court, looking both at the jurisdictional issues regarding the 30-day as well as the park forest issue. I would like those, if you could, that if I could receive them at least by the Monday prior to the, what date that is, the Monday of that week of the 14th. I would appreciate it. Give me a chance to read it. Any questions?
No questions
None
from
from-
plaintiff.
Thank you, folks.
Thank you.
Thomas Tiplady. Scala.
All right. All right, where are we on this, gentlemen?
Did you get a copy from the front of the 508 that I previewed? Oh, sorry. We've also had some discussions since the last court date, both here in the parking lot and a couple phone calls and a in-person in the last few days that, you know, we're far apart, but we're trying to stay polite.
My turn.
Go ahead.
I'm having a hard time understanding this exactly. I've known Louis a long time. A few years ago, his mother died and he inherited a house in Florida. He has that house, and just recently he had some money problems trying to line him up with the Social Security check with the date of the payment. And he was late a couple of times. That's never been an issue with me. I covered him when he lost his business and took months, and that was fine. I'm good with all that stuff. But now he just got an inheritance and gave me a picture of the check, $337,000, $337,000 something 15 cents.
You guys are not in agreement on this at all.
Well, why is he doing it?
I don't know, but are you not in agreement?
No, I want him to leave. I'm kind of in a problem as a time pressured, and I want to get him out, and I want to get the house fixed up so I can have my granddaughter move in so she can help me out with my wife. And I want to have my stepdaughter take over the financials of it, because I spend 3 hours a day looking for my phone. And so, I mean,
At non-jury trial in this matter for August 25th, 2026, 9 a.m. All in person. Make sure to bring all of your witnesses, all of your exhibits, and then I'll hear testimony at that point in time. Thank you.
August 25th, 9 a.m.
Yeah.
Thank you.
I'll get that out there.
Yes, sir.
May I ask one question? Is it possible? Louis just informed me he hired a lawyer now, and this is the first thing that the lawyer did. And is it possible for a lawyer to continue to submit things to you, contents or motions or whatever, and postpone this? Because Louis says he's happy to leave in November, but he's not going to leave until November. Possible?
I don't know, sir. It's possible for me to answer that question.
You understand what I'm asking?
I do understand you.
Okay,
Possible for me to answer.
fair enough.
Thank you.
Thank you.
It's a certain, sir.
I'm sorry. Oh,